Newmarket Zoning Board of Adjustment meeting for Monday, September 12th, 2016. And the first order of business is the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Evening, James. Our first order of business, aside from the Pledge of Allegiance, is a review and approval of the minutes of August 22nd, 2016.
I make a motion we accept them with Diane's corrections, the version Diane sent out,
Edited version.
the edited version.
Do I have a second?
Second.
Any further comments? All those in favor of accepting the minutes of August 22nd, 2016 minutes as amended by Diane, please signify by saying aye.
Aye.
All those opposed? And Mr. Shelton abstains for absence, and James, you weren't here either, right? James abstains. Other than that, it's unanimous, and Mr. Rosa, of course, does not get a vote. And our third item of business is application of Jane Rosa and Paul and Sally Rosa, which is a continuation of a public hearing for an application for a variance from section 3.01 of the Newmarket zoning ordinance to permit the subdivision of a residential lot containing approximately 4 acres with road frontage of 37.85 feet, where a frontage of 200 feet is required. The new lot will share a driveway with the property at 340 Wildley Falls Road. The applicant also requests the zoning board confirm that the remaining land will remain a non-conforming lot. The property is located at 342 Wildley Falls Road, tax map R5, lot 81 in the R1 zone. And in addition to that, there is a application from the same applicants for a public hearing on an application for a variance from section 1.05C1 of the Newmarket zoning ordinance requested by Jane Rosa and Paul and Sally Rosa to allow the change of a boundary of an existing non-conforming lot which does not meet the current 200-foot frontage requirement in a way that does not bring the lot into closer conformance with the zoning ordinance. The applicant proposes to subdivide the 45-acre lot to create a new 4-acre non-conforming lot with 37.85 feet of frontage, thus increasing the nonconformity of the remaining lot. The property is located at 342 Wildley Falls Road, tax map R5, lot 81 in the R1 zone.
And
Mr.
I'm
Rosa.
going to recuse myself.
Thank you, Mr. Rosa. And Attorney Schulte, whenever you're ready.
Thank you. Members of the board, my name is Jim Schulte. I'm an attorney from Dover, and I represent these applicants. As the chair mentioned, we are seeking 2 variances, both for the same cause. Paul and Sally Rosa own 45 acres of land, which extends into Durham. Currently, Wayne Rosa owns this. Mr. and Mrs. Wade own the pink piece, and approximately here is where the proposed lot would be. We haven't had it surveyed yet because we need the variance first. There's 37 feet of frontage which would belong to this, which exists between the Rosa lot and the Wade lot. Down here, when this lot was originally created and then subsequently was expanded to add this, which reduced this frontage here, and some frontage came off this corner. So that side of the property, the easterly side of the property, actually has something over 70 feet of frontage currently. There's an existing large driveway which goes to the back of the existing Rosa parcel for Wayne's business. It's probably a dozen feet wide. It's very solid and substantial. It's an ample-sized driveway to provide enough access for both Wayne's property and for the property that we're going to subdivide out in the back. The land on this side is all owned by the Audubon Society, so will never be developed. And the land on this side is owned by Mrs. Sewell. She lives elsewhere, but she owns that property. Her land also extends into Durham. Currently, there's a big red barn near the road and a couple of outbuildings, but there are no dwellings on that property. The likely location for the new home that would be built by Jane and John would be probably 300 or 400 feet from the Wade house, so it's not going to be close. There's some trees in between, so there'll be a substantial separation. I will quickly run through the criteria. Variance would not be contrary to the public interest because this will not constitute a substantial change in the character of the neighborhood. There are other properties in the neighborhood which actually have less than 200 feet of frontage, although none has as little as 38 feet. And there are some other properties in the neighborhood where houses sit back substantially from the road, some further than this. We won't need a new driveway, which is a significant advantage. One of the purposes of the ordinance, the frontage requirement, is to limit the number of entrances onto a highway. Second purpose is to make sure that there's safe access, sufficient room for safe access to the back. And the third is to make sure you don't get buildings crowded too close together. And so, since this new home is going to be located not between the existing homes but out behind, there's no spacing problem. We meet all setback requirements for that. And we will not be adding a new driveway. Variance would do substantial justice because this development is reasonably consistent with other properties in the neighborhood. It's for a single-family residence, which is expressly permitted. There's no detriment to the public involved in this. This substantial justice criteria requires that you balance the interests of the applicant versus the interests of the general public, and there's no detriment to the general public to allow this property to be developed, particularly where we're still going to be reserving 40-some acres of open land out into the back. Granting the variance will not, the variance itself is not going to have any impact on abutting properties. The new house is going to be several hundred feet away from existing residences. It has no impact on the Audubon Society property on the east side, and the Mrs. Sewell's property is not developed. If instead of this proposal where we're asking simply to put one house out there, there was a proposal to put a major subdivision out there, there could be a house in exactly the same location that will be existing if this variance is granted. And so the variance itself is not going to have any impact on abutting property values, because you could have a house there and have the identical impact with or without the variance. But the Roses don't really want to develop the rest of this land. They're content to leave it as open space, at least for the indefinite future. The final criterion is whether literal enforcement of the ordinance creates an unnecessary hardship. And that means that owing to the special conditions of the property, no fair and substantial relationship exists between the general purposes of the ordinance and the specific application of that provision. The purpose of this frontage is threefold, as I mentioned. One is to limit the points of access onto the highway. Second is to make sure that there's adequate space for safe access to the property out back. And the third is to make sure that there's adequate spacing between buildings, and we meet all of those. So applying the technical requirements of frontage in this case is not necessary in order to meet the objectives, because we can meet all the objectives of the statute, of the ordinance, by this development proposal. The proposed use is a reasonable use. Ultimately, as those of you who have been on this board for a while, and I suspect that's quite a few of you, know that in the last dozen or 15 years, we've had quite a change in the hardship definition under the zoning ordinance. We've gone from the point a few years ago where if there's anything else you could do with the property, you couldn't qualify for hardship, to the point now where the test is this a reasonable request for this sort of land? And this allows reasonable development. It allows Jane and her fiance and their daughter to build a home in their neighborhood where their uncle and parents and grandparents live, and still satisfy the basic requirements of the ordinance. I would be happy to answer any questions about this.
Before we get to that, there's a couple of housekeeping things I neglected I should have done earlier. First is I'm going to ask Mr. Shelton, since there's only four of us, to sit on this application.
Thank you.
And Steve, I'm just doing that by seniority. you're gonna have to fight it out with Rich if
Yep.
you prefer to have it be you.
I think you could beat me in arm wrestling, so there's.
Absolutely.
And I didn't specifically address the second request for variance because it's really part and parcel, because you can't really count that 37 feet of frontage for purpose of determining whether this is conforming, because you can't add those together. But we are in fact changing that. The strict definition in your ordinance says if you change a non-conforming property without making it more conforming, you need a variance to do that. And we are changing it. It will be less conforming, even though the conformity doesn't really make much difference to any of your standards. It is still a change.
There's one other housekeeping thing I need to bring up, which is my law firm represents one of the abutters. I'm not personally involved in that, and I know enough about it that it has absolutely nothing to do with this application whatsoever. So I'm comfortable continuing to sit on this, but I wanted to give you a chance. And if you wanted to talk to your clients about it,
We,
if that's an issue. There has been no objection from any abutter.
I'm sure it's fine. I mean, it's really up to your judgment as to whether you need to
Right.
recuse yourself, and we'll rely upon what you say.
Okay, I just wanted to give you a chance if you wanted to weigh in and put something on the record. I'm perfectly comfortable that I can evaluate this fairly.
Good.
And I don't know if there's something came in from Durham that they have no objection
Good.
to the application, just so that's in the record as well.
Durham does own some property back there, so,
Yeah,
yeah.
so I just wanted to put that out there. Are there any questions for Attorney Schulte? Or is there any objection to me not recusing myself? Because
I do have a question. Is there going to be any intent to make a perpetual easement through the
Yeah.
deed for the common
I was
driveway?
going to ask if there's going to be a driveway sharing agreement of some kind.
There
Because in the
will-
future, the property might get
There
conveyed.
has to be.
Yeah,
As part of the subdivision process, we have to go to the planning board, and that will be a requirement, that there will be a deeded easement across the existing driveway, so it will be a permanent easement.
okay.
And the second question I've got is the strip, what is it, the strip to the south, to the east, I guess. That's adequate to put in a full 50-foot right-of-way if they decide to do something?
Yes.
If a future property owner decides to do something, we haven't created a spite strip or anything that's going to make it difficult for future use?
No, it is wide enough. The actual street frontage is about 70 feet. Most of this distance is just over 50 feet, which is what the planning board would require. So whether it's an alternative design subdivision or a formal, full-scale subdivision, neither of which is contemplated, that could accommodate it.
We've seen a lot of stuff that wasn't complicated 30 years ago come to fruition, so.
Yeah, I've been around a little while, too, so, yeah. And lawyers do two things. They make easy things simple and simple things complicated, so,
Objection.
sorry.
I don't have any more questions, really.
Diane, did you?
Well,
wanna-
just a follow-up to what Bob was asking. There is enough road frontage for a road. What about the suitability of the land conditions to support a road in the future if
It-
somebody chose to develop it? So are there wetlands? Are there steep slopes? Are there any, is there ledge? Are there any physical conditions that would preclude that land from being subdivided in the future?
Wayne could speak to that better than I could, but from my personal observations, it's level, it's buildable. There are wetlands toward the back of the property, but nowhere close to where that is. But
I have looked at Google Earth, because Google Earth has got the
I
answers
didn't
to all
hear your
questions.
question, Diane.
My question was, we talked about there's adequate frontage for a road in the future. What about the suitability of the land to support a road? And I was questioning if there were any wetlands, any steep slopes, any ledge, or any physical conditions that would preclude building a road to access that back land in the future.
This configuration may not end up entirely like that because of exactly what you're saying. This road I should say, we should allow for something to come in here, because I suspect that the stream right here, and I suspect that the wetlands, this will be delineated right in, probably about this area right in here. So this will probably go over to this point to get the road a little bit over in here for the future.
But this question is level.
Right in here, there is nothing. The only thing that would restrict it would be this wetlands that comes from this stream that's right here. But there's no ledge, no wetlands. This is all high and dry right here.
That's good, thank you.
And with or without this variance, that's what it is. You either could build out there or you can't, because taking this out is going to have no impact on that.
No, I appreciate that. We're going to take a look at this application and worry about the future
Sure.
at some point down the road. Any other questions or comments for Attorney Schulte, for the applicant?
No, I agree that that I will vote yes on this application. And I've spent a lot of time going through the variances, and I've drawn up enough so that I would be willing to go through all the variances and make a motion if in fact everybody is comfortable with it and they all want to agree with it, unless they've got other problems with it and they want to vote against it. Well, then we have to sit here and discuss it.
Considering we could be sitting here looking at a 28 acre subdivision, I think this is an excellent use for the land. Thank you.
Yeah.
Just keeping it as open space for as long as possible, so that's a good thing.
The only thing I want to say, because the last application we had, which ended up in court, and there was some contention to it, we went on with 3 or 4 meetings on it, involved 1.05C1. Part of what that involved was an application that made the property less conforming, and we denied it in part on that basis. So I think I just want to put in the record why I think this application is different, which is the configuration of this lot is very, very unusual, in my view. And this is to me, it satisfies the hardship criteria because of the way, I guess what I'll call the backlot more or less wraps around 340, or I guess it's 340 Wildly Falls Road. It's just a highly unusual. I've never seen a lot that looks quite like this one. So I think this application is very reasonable in light of a highly unusual configuration of this property. I just want to put that on the record, so that's...
But I thought the judge had said that the non-conforming, we'd made the lot conforming, so our vote to deny
Yeah.
was...
It's a very different set of circumstances, very different set of circumstances, very different configuration of lot. That was a property where there was already 3 existing residential units on one lot. This is not that application. So I just want to make sure that we're clear on that there's a reason why we're distinguishing this application from that one, because that one was so contentious.
Yeah.
With that comment.
It wouldn't have been no problem if we didn't have the buildings on that other lot. But it's what it is.
It is what it is.
Yeah, it's what it is.
If there's no further comments, Rich?
I yield the floor to Rich. Love to hear
If
your...
you want to go through the variances, I can go through them all.
Go ahead, Rich.
Okay.
This is a motion, correct?
Okay. Well, I'll read the statement of facts first.
Okay.
Granting the variance would not be contrary to the public interest, would not alter the essential character of the locality or threaten the public health, safety, or welfare, and not be contrary to the public interest. The variance were granted, the spirit of the ordinance would be observed because the spirit of the ordinance would be observed as sharing an existing driveway would be consistent as other properties in the area that also share an existing driveway. The existing driveway located at 340 Wadley Falls Road has excellent viewing both east and west and provides for safe access and egress to the road, thereby eliminating an additional access point to the road. The structures will safely satisfy all setback requirements. Granting the variance would do substantial justice because the proposed residential use is consistent with other uses in the area, the neighborhood, that also have limited road frontage. The lot of 4 acres will meet all zoning requirements, only lacking road frontage, and by sharing an existing driveway, substantial justice is satisfied, is that any loss to the individual that is not outweighed by gain to the general public is an injustice. Variance were granted, the values of surrounding properties would not be diminished. So stated by the applicant, the surrounding properties will not be diminished. The 4-acre lot is an expressly residential use allowed in this zone. There will be no visual impact to other properties in the area, and the remaining 41 acres of the property will remain undeveloped. The unnecessary hardship. No fair and substantial relationship exists between the general public purpose of the ordinance provisions and the specific application of that provision to the property. The proposed use is a reasonable one, and I use simplex under unnecessary hardship, 145 New Hampshire at page 731, 733, 32. A zoning restriction is applied to their property, interferes with their reasonable use of the property, considering the unique setting of the property and its environment. A self-created hardship does not preclude the landowner from obtaining a variance, since purchase with knowledge of a restriction is but a non-dispositive factor to be considered under the first prong of simplex. And I reference Hill versus the town of Chester, 146 New Hampshire, 291 and 292, year 2001. As this use for a single-family resident on a lot of 4 acres where 2 acres is lacking, only lacking road frontage is reasonable. No fair and substantial relationship exists between the general purpose of the zoning ordinance and the specific restrictions on property. As the only restriction applying to this property and its environment is lacking road frontage where 200 feet is required, the applicant has shown that by sharing the existing driveway with 340 Wadley Falls Road will ensure safe access to each property owners and others, and by reducing curb cuts will result in lessening traffic control points, and thereby, I quote, support quality, thoughtful development that preserves our natural resources and enhances the aesthetics of Newmarket while creating a long-term tax base, unquote, as part of the master plan vision statement. And then C, the variance will not injure the public or private right of others. The variance will not injure the public or private right of others, as this lot of 4 acres where 2 is required and only lacking road frontage does not have any adverse impact on the health, safety, convenience, or general welfare of the community. And I reference Chester Rod and Gun Club versus the town of Chester, 152 New Hampshire, 577 or 205, an analysis of public interest. Having met the 5 parts of the variance from section 301 of the Newmarket zoning ordinance, I will make a motion to permit the subdivision of non-conforming residential lot containing approximately 4 acres and grant approval for a single-family residence with road frontage of 37.85 feet where 200 feet is required as shown on the plan of land for Paul and Jr. and Sally Rosa, Newmarket, New Hampshire by Teton Land Consultants, Incorporated, dating 22 April 1988. The lot is located at 342 Wadley Falls Road, tax map R5, lot 81, R1 zone with conditions. And I think the conditions are going to be taken up on with the planning board on the subdivision. But I noted, though, on my notes that the easement of the shared driveway of the 4-acre property with the abutting property located at 3040 Wadley Falls Road shall be so noted and recorded on the deed. The land use change tax shall be assessed at fair market value, and impact fees will apply, but those are planning board issues. But I just wanted to put them there for our notes.
I would be pleased to second that motion.
The only thing I would add to that is that I would suggest adopting the information, the factual information contained in the application as part of our findings to support granting of the motion. We'll do them separately. Okay.
Just curious.
So what Rich has just read to us is for approval of the application, of the variance under 3.01 only. So what I was going to propose is that we act on this, and then we can come back and say, for the reasons previously stated, we grant the the request for the second variance as well, just so Rich doesn't have to read all that again.
I did make a separate motion for that
Okay.
second part.
So you're way ahead of me. Good.
It's right on top of it.
Okay. So is there any further comment on the motion as to section 3.01 currently pending?
Did we want to give the public a chance to?
Oh, we never did have any public comment. Is there any public comment on the application? I apologize. I should have done this much, much earlier.
She's got no problem.
You don't have to comment if you
Remember
want to
that-
comment.
Remember that time he did that to you? Now's your chance.
I apologize. We should have done public comment much, much sooner. But I see so many members of
Well,
the
we
Rosa
we
family.
haven't
I
took
just
the final
assumed-
vote yet.
Yeah.
I
So
don't-
if there's any public comment now, please step forward, and we're happy to hear you. Okay. Seeing no public comment,
Don't forget the Durham letter.
and what about the Durham letter? I did mention it.
Okay.
In the file.
I did mention that Durham had no objection,
Right.
and there were no other objections from any abutters. No objections from any abutters, not no other, no objections, period. Okay, we ready to vote?
Yep.
All those in favor, please signify by saying aye.
Aye.
All those opposed?
It's magnanimous.
It's unanimous. Mr. Shelton, you had a further motion.
Okay, on the second motion, a motion for a variance from section 105C1 of the Newmarket zoning ordinance requested by Jane Rosa, Paul, and Sally Rosa to allow the change of a boundary of an existing non-conforming lot of 45 acres, plus or minus, with two separate road frontages of 37.85 and 71.54 feet on Wadley Falls Road for the sole purpose to subdivide the 45-acre plus or minus lot to create a new non-conforming 4-acre lot. By allowing this change, the new 41 plus or minus acres with a reduction of 37.85 road frontage to 71.54 feet, which does not meet the current 200-foot frontage requirements, thus increasing the nonconformity of this lot located at 342 Wadley Falls Road, tax map R5, lot 81, R1, zone. I make a motion to approve it.
Do you have a copy of that? I can just stick it in the file. Thank you.
That's the only one I had, but anyway, it's okay.
I'll second that.
So this is a motion to approve the variance requested under section 1.05C1.
Right.
Yes.
Right, okay. Any further comment? Any public comment on this particular variance application? Seeing none, close the public comment on that. And any further comment at all? All those in favor, please signify by saying aye.
Aye.
All those opposed? The ayes have it. And both of Mr. Shelton's motions are going to be in writing in the file. Thank you, Rich, for doing that. That was a lot of work.
It makes us sound good, too, thank you.
Any new or old business to come before the board at this time? Just remind everybody, tomorrow is state primary voting day. Vote early, vote often. Be nice to your election officials,
Especially the moderator.
especially the moderator, because he's very old and decrepit.
Is he late?
Thank you.
Thank you.
Now comes the hard part, the subdivision.
There's no new business or old business to come before us. I entertain a motion to adjourn.
Could you get me a copy of that approval?
Yeah,
Sure, we will. We'll send a letter to you.
it'll be written up,
We'll send you a letter in
and
the
you'll get it
mail.
in writing.
Certified. Yes, we will send it to you in the mail.
Oh, okay.
Okay? Thank you very much.
Yeah, well, it looks in pretty good shape.
I'll entertain a motion to adjourn.
Second.
All those in favor, please signify by saying aye.
Aye.
Those opposed? Thank you, Chris. Good night, everybody.